Many ethical issues emerge throughout internal investigations that must be considered by in-house counsel and outside counsel, including who is the client, whether in-house counsel or outside counsel should conduct the investigation, joint representations, disclosure in employee interviews, and whether to self-report to the government. Wheeler Trigg O'Donnell trial lawyer Habib Nasrullah will address ethical issues faced by in-house and outside counsel as they navigate through internal investigations. Please welcome Habib.
Good afternoon, everybody. There's 5 primary topics that I'd like to talk about today, and these deal with, of course, the various ethical issues that we face conducting internal investigations on behalf of clients. None of these are particularly new or cutting-edge issues. These are issues that have been around for a while. The legal principles have been around for a while, and the model rules have been around for a while. But those of us who do this work, keep in mind that this can be a minefield of ethical issues once you start investigating your own client with an eye towards self-disclosing criminal conduct to the government. So the 5 different areas that I'd like to touch on today. First is, who is the client? Who conducts the investigation? Should it be outside counsel or inside counsel? What about joint representations? Should you consider having your law firm represent the corporation as well as one or more of the officers, directors, or employees? What are the ethical pitfalls in interviewing employees of the corporation when you represent the corporation? And what are some of the considerations that should be going through our minds when we make the eventual decision that keeps most of us up all night, is whether we need to walk into the lion's den and self-report to the United States? So the first question I'd like to touch upon is, who is the client? And this, in the internal investigation context, is something you have to think about long and hard. You may walk in and you may get the phone call saying, we need your law firm to do an internal investigation. And the first question really needs to be, and it sounds fairly trite, but who is my client? Am I representing the corporation? Am I representing an audit committee? Am I representing potentially an independent monitor or an officer or director? And it is worth spending some time trying to figure that out and document exactly who you're representing and what the scope of your work is going to be. If you are representing the corporation, your ethical duty, not surprisingly, in an internal investigation is to ferret out and find wrongdoing. Your ethical duty is to conduct an effectual investigation, and we'll touch on some examples down in a few minutes of ineffectual investigations in which internal investigators have paid a very, very high price. And once you find out, or once you are concerned about the wrongdoing, there's simply no way of not advising your ultimate client, which is the corporation, even though the information might come from various constituencies of the corporation, like the employees or the auditors. Now, what do you report when you're representing the corporation? You report a violation of the law, or you report that something that isn't necessarily a violation of the criminal law, for example, but if you come across something that could cause substantial injury to the corporation under Model Rule 1.13b, that is something you absolutely have to bring to the corporation's attention. Who does internal investigations? And I thought Joel's presentation on the fire and the scrutiny that in-house counsel are getting these days was very, very important to us. At one time, there was sort of a common feeling that you always had to go outside to have an effective internal investigation done. And I think that given the growth of compliance departments in this country, and given the amount of former prosecutors that are going in-house, There are a lot of very competent in-house internal investigators who do a number of investigations on a number of different issues. But the fact of the matter is that the government tends to look at in-house counsel a little bit differently these days. In-house counsel are far more scrutinized, particularly from the SEC, from other regulators as well. There's always a question of, did they condone the wrongdoing? Did they have any obstructive role in reporting the conduct? Was there any concealment of this crime? So you don't always have to go in-house to do the investigation. If you have appropriate, good, competent in-house investigators, which most corporations have, that's certainly a consideration. Cost is always a consideration, but there are some investigations that you have to go outside on. In-house counsel, in addition to the subjective concern of the government as to their neutrality or impartiality, there are privilege issues you have to deal with. And in internal investigations, unfortunately, in the past, the government has required internal counsel or counsel investigating the violation to turn over their reports and their interview notes. And internal counsel have more information about the company. External counsel don't know a lot about the business of the company. But certainly there are more privilege issues when you have internal counsel do the investigation. We do know that privilege is more scrutinized when it asserted on behalf of in-house counsel, and there have been a number of cases that have come out of the civil realm, and most of you are familiar with. There's one in New York that I cited in the materials, which is Rossi versus Blue Shield, which says that the privilege is cautiously and narrowly construed and heightened in the case of corporate staff counsel, because the concern of the courts is just by simply plugging a lawyer into an email chain or into a memorandum that could be viewed as an attempt to somehow shield the communication from disclosure, so courts tend to be somewhat wary of that. Now, one of the things that I think is an ethical issue, which I'm not going to be able to really point you to a model rule, it's a gut check, and that is what I would call, the investigator's first job is to try and figure out whether he can do an effective investigation. Our country and our world is becoming highly specialized. There are a number of overlapping regulatory regimes, and the first question you really need to ask yourself as an internal investigator is, can we do this? Can our law firm actually take this on? And I've been in the uncomfortable position sometimes of having to turn away business, and particularly large pieces of business, because we don't have the resources to take on an internal investigation of that magnitude, or we don't have the specialization. If we take on an internal investigation that does require some degree of industry knowledge, I will take it only upon the client's consent and express approval that I can hire competent support. And what I mean by that is I just finished an internal investigation on export controls. The product there was chemicals that had been exported all over the world. I'm not a chemist. I needed to hire a chemical engineer. There were processes involved. And you frequently have to go to Washington and hire somebody who's not necessarily a lawyer, but somebody from the outside who can help you with intricate Commerce Department export control classifications and things of that nature. So my point is, it is very, very important for outside counsel to make the determination ethically that they are competent to do the investigation, or alternatively to make sure that if they feel the need to hire specialized talent, regulatory or industry, that they absolutely have the resources to do it. Otherwise, don't take it on. The downside to taking on an investigation and not uncovering the wrongdoing, that the government somehow is able to uncover later, puts you into a very compromised position and potentially turns you into the target of the government investigation. That's what happened in the Enron case. They hired Vinson and Elkins, and it wasn't that Vinson and Elkins was viewed as by the government as incompetent to do the investigation. But in that case, Vinson and Elkins, and I believe it was Vinson and Elkins, I may be wrong, but they were viewed by the government as a firm that routinely did work for Enron. And as a result of that, became somewhat perhaps conditioned by the company or affected by their perhaps their loyalty to the company. And the government took the position that they flat out failed to uncover a whole bunch of accounting fraud, and they ended up paying $30 million to the regulator. Global Crossings was the same way. The firm that handled Global Crossings, the internal investigation, was their regular outside counsel, was viewed to be by the government as ineffective, and the firm paid a whopping fine to the United States. So it's really important that when making the decision to take on the investigation, that from the in-house perspective, if you've got a significant investigation, you have to hire a firm that you think will be perceived as being effective, or certainly not implicitly disqualified by an ongoing relationship with the client. Joint representations. I don't know, most of you who do this work run across this issue all the time. And you get a call from the in-house lawyer saying, I need you to do an investigation. And I say, who am I representing? And they say, you're representing the company and 5 of the employees. And you go, oh gosh. And you start thinking immediately about your letter of retention. What's that going to look like? It's a very difficult position to be in. And you know, you can, as you all know, you can take on joint representations. We do it frequently in the civil world. We do it in the investigative world. I hate doing it in the criminal world, but we have to do it. Under the model rules 1.7a, you can actually take on a joint representation unless there is an actual conflict when 2 people are directly adverse. You're not going to get that situation when 2 people are directly adverse. But you have to evaluate under 1.17 whether there is a significant risk that representation of the corporation will limit your ability to represent the individual who you may have been asked to take on by the company. And you can do it, but you have to make a determination under 1.17b that you reasonably believe that you can represent both adequately and competently. Now, here's the problem with that. You're going to start representing them, and then you're going to start reading documents, and then you're going to interview people, and you're going to think, well, maybe there isn't this conflict. But the problem is 6 months down the road, you may find a witness or you may find a document that was in Shanghai, and all of a sudden you've gotten a hold of it for the first time, and you realize that there's potentially a huge conflict between the individual and the corporation. And your client, the individual, probably hasn't brought this to your attention because he well knows that you represent his employer, and he wasn't about to tell you about that sometimes. So that is something that you really need to keep in mind with joint representations. I always try and talk in-house lawyers out of it. Or maybe we should find your employee another lawyer, or I'll represent him, and maybe find the corporation another lawyer. But sometimes practical concerns dictate joint representations, and we do them fairly routinely. But the key here is you absolutely have to get informed consent. And you know, I know this sounds like a broken drum, and everyone says, we have that in our letter of retention. But the case law suggests that sometimes when we send out these letters on joint representations and we say, we're representing you both, we don't believe there's a conflict. However, if a conflict were to develop in the future, we have the right to drop you, employee, as a client, and we'll find you somebody else, but you can disqualify us from representing the employer. That is sort of your standard language in most letters of retention. And some courts have said, yeah, you know, not so fast. Not so fast. And believe it or not, this has been called something. Have you heard of the hot potato rule? I thought people were making this up, but the research tells me, and I did the research on this, when you have a situation, you have a joint representation, and let me just tell you about this case. It's called Picker versus Varian, because this is the craziest thing I ever heard. Picker and Varian are in a patent fight. Varian is represented by a small firm, and Picker is represented by Jones Day. Well, Jones Day is out in acquisition mode, and they swallow up the firm and merge with the firm that's representing Varian. So one day, both litigants, Varian and Picker, get a letter saying, you're both represented by Jones Day. I mean, you can't make this stuff up, right? So Varian promptly moves to disqualify Jones Day. Jones Day says, no, we can do this. We can China wall. We can create a China wall within our own firm and have this side of the firm represent Varian, and we'll keep Picker. And the court said, no, that's not going to happen. And guess what? You can't, Varian was the small client. Jones Day then said, all right, we'll drop Varian, we'll keep Picker. We have a pre-existing relationship with Picker. And what the court figured out, cynically, was that Jones Day had been paid a lot of money by Picker over the years, so they're trying to keep the more lucrative client, right? Can't blame them for that, but they tried. And the court said, no, you're not going to do that. You can't drop one client, especially if it's in order to keep happy a far more lucrative client. So Jones Day, you decide to merge with this firm, you're done. So both they got disqualified from the entire litigation. Picker and Varian went out, hired new counsel, and started all over again. God knows how much that cost, but they did that. The minority rule upholds the kind of letter I was talking about, which is advising both sides that it's a joint representation, and if there is an adversity that develops or conflict, we retain the right to represent one of you over the other. And some courts say yes if the letter is signed, and yes if the clients are sophisticated enough to understand what they have just done. And in some circumstances, that might warrant an inference that what's called an accommodation client consented to being essentially having their representation terminated. I would never call a client an accommodation client. I'd like the record to reflect that. What that seems to suggest is that the client you take on whose life may be hanging on the line, the employee, as opposed to the corporation, is somehow characterized as the accommodation client. I think we need to be really careful with these reps simply because, for the reason I just mentioned, the corporation get charged, it's an entity, these folks have their lives hanging on it. I think they always deserve separate, independent counsel. And these kinds of arrangements, when you have any concern that the Department of Justice is involved, really should not be done, and I think the courts are scrutinizing them more and more. There's one case that illustrates the conundrum of a joint representation, and it actually came out of a DC bar opinion. And I'll tell you the facts of this case because I think it puts it into context. It was a law firm in DC that represented a company who hired an alien employee who needed a green card. And so, the company says, we'll pay for it. Go ahead, file your petition with the INS at the time. And the law firm says, fine, we can certainly represent you both. We think there's a congruence of interest here. And they filed the petition. The alien employee is granted his green card. After that, he gets his green card in pocket. He makes a startling disclosure to his lawyer, the law firm, and says, by the way, I didn't tell you this, but everything I said in that petition was wrong and false. Talk about a showstopper, right? So the law firm very prudently writes the letter to him, doesn't copy the employer, who's their other client, and says, we just learned about your disclosure to us. Verify and sign this piece of paper saying you hadn't told us prior to the time we filed this petition on your behalf because they didn't want to be caught with false statement liability of the United States. The employee did that, and the law firm then went to the DC bar and said, we are in an ethical situation where we feel that we are compelled to share the information that the employee gave us with our other client, the employer, who paid for the representation. And the employee probably would not have consented to this disclosure. A, he would have got fired. B, he would have probably gotten prosecuted. But the law firm sought the opinion, and the DC bar came back and said that because the lawyer did not seek, in the context of the joint representation, language in the letter that in advance, that if there's ever any communication that between the clients, we have to disclose this to both sides. It's essentially an advance consent on communications in a joint representation. If you ever do them, you probably ought to get that, because that's something that's important. And in this situation, the Bar Association DC came back and said, you have got to do one or two things. You got to either get your client, the employee, to consent to the disclosure. You got to get him to make the disclosure. And if he doesn't do that, you have to withdraw. And you can't do what's called a noisy withdrawal, which is you can withdraw and advise the government that you're withdrawing because you have some concerns as to the integrity of the application. You just have to simply withdraw. So that was essentially the situation. So joint representations, and I think we are out of time here, but joint representations are fraught with peril, and I would advise you to approach them with a great deal of trepidation. There's other things I think if anyone has any questions on the materials, please feel free to ask me. But thank you very much.